That concludes the public hearing portion of tonight's agenda. We'll now move on to item number 11. Kay, you can come back and join us. This is unfinished business. Item 11.1 is to reconsider council's direction to have the city manager come back to this city council to authorize judicial foreclosure attorney fees greater than $20,000 and by minute action remove the $20,000 cap on fees relating to the agreement with Sherman Feller as foreclosure counsel. Ms. Sato.
Good evening, Mayor and Council. As the Council will recall, at the meeting of January 13th, 2009, the City Council adopted a resolution for judicial foreclosure and hiring the firm of Sherman Feller. The only stipulation that the Council made, because we didn't have information as to how much it would cost, the maximum amount it would cost, was that if the legal fees were going to exceed $20,000, we would have to come back to council. After speaking with Susan Feller, who is the partner in the firm, I found out that due to the unique nature of this type of lawsuit, there's no maximum fee that she can agree to because of the amount of fees and costs in a foreclosure lawsuit are dependent on many factors. For example, there could be multiple owners of the property, and each one has to be served, and it takes legal time to do that. In one case, Ms. Feller had 64 owners that had to be served on a piece of property. And so they have to take the time to do everything they need legally in order to pursue the judicial foreclosure. However, she said that generally speaking, $20,000 is more than enough for the legal costs. And she will defer the fees until such time as a judgment is entered and the property is sold in most cases. As long as we can sell the property. If we can't, then she won't be able to do that. And in cases of settlement prior to entry of judgment, she will also defer the fees until and put in the city legal fees as part of the recovery. This type of lawsuit is kind of unique because it differs from many others, because when the case goes to judgment, the attorney must submit their legal bills to the court. So there is some review of it. The person that really pays the legal bills is the person who's foreclosed upon, because that is part of the judgment. They lose their property. So Sherman Feller really can't agree to keep track of the fees and costs and go back to the council before they go beyond 20, because that would subject her to having to continue the lawsuit without any compensation, because the judge is the one who would relieve her from her duty to pursue this lawsuit. As discussed in the staff report, there was, of January 13th, there was a large delinquency in the North First Street Assessment District. The property is worth more than $1 million, and there is a past due assessment of approximately $100,000, including penalties and interest. A judicial foreclosure action would likely result in the sale of the property for enough to cover all attorney fees in judicial foreclosure actions. The attorney fees are subject to review by the court, because it is a fiduciary responsibility to make sure that the property owner does not, they have an opportunity to object if the fees are excessive. The attorney does defer the fees in most cases. The bonds issued in connection with the North First Street Assessment District are a limited obligation of the city, and a default would not affect the city's credit rating except if we did not adhere to our covenant to the bondholders, which is to pursue the judicial foreclosure action against any property owners that are delinquent, seriously delinquent. Failure to follow this covenant would be considered an event of default and would impact the city's credit rating. So with that, I'm recommending that the council would consider its action, because there are protections in this particular case.
Just one comment. As I'm reading the staff report, this is common just not to Sherman Feller, but to any other group that we would contract with to handle our issues. So it is not just something that Sherman Feller has come up with. Right. This is common throughout the field.
For this particular type of
recovery, if you will.
Right. And I'm sorry, I did not have all that information when I brought it to council on January 13th.
All right.
But with the additional information, I'm requesting a change in council's direction.
Okay, any questions of Ms. Otto?
I'd like to know, you say that the money to pay the legal fees would come out of the North First Street Assessment District Fund?
In the event we can't recover it through the sale of the property,
Right.
or in the event we have to advance it for some reason.
And how much, was this part of the bond sale to begin with, was to reserve a certain amount of money for that contingency?
Yes, but however, we do have some surplus in that fund, and I'm going to be coming to council shortly to deal with that.
Yeah, well, shouldn't the surplus be returned to?
Yes.
the
Yes, that's
people
what
that
we're
pay?
going to be dealing with.
Okay, and, well, I'm just wondering, how much in the fund is dedicated to the purpose of defaults?
There's nothing specifically dedicated. All the money in the fund can be used to cover defaults. We probably will not refund enough bonds, all the bonds that we possibly can, because we do have to have some money in the case of default. Beyond that, you do have the reserve fund, but that would be an event of default that we don't want to get into when we have money already that we're collecting from property owners.
Right.
So that would be something we pursue only if there was not enough being collected from the property owners to pay for
Right.
that.
And my worry is that if we have enough foreclosures, that somehow it affects the people that are still left paying bonds, and that they end up having to lengthen their payments or have to fund this in some way.
No, that will not happen, and the reason why it will not happen is because there's only a certain amount that we can collect from property owners. If it were to be that for some reason that the whole property were to be in default, then we would declare an event of default, and it would not hurt the city's credit rating, and we would use the reserve fund to pay for it. But in this case, this particular property is reputed to be worth more than $1 million. And I do not believe that any property owner or mortgager that subsequently obtains that mortgage is going to want to let that property go for $100,000 when it's worth $1 million. Because remember, as I discussed on January 13th, if there is a judicial foreclosure, it wipes out the first mortgage. So if there are individual property owners that owe small amounts, if they fail to pay their assessment, there's a foreclosure action, then the new property owner, that would be in this case the bank, they would be very well motivated to pay off that assessment for a few $1,000s if it was a single family home. In this case, this is a large parcel that has not been subdivided, I believe, or it's a commercial parcel, rather.
Well, with the banks in the condition that they're in, who knows what the banks are able to do financially now. I have no problem with this. I just wanted to make sure that the homeowners are protected and that people will not see an additional cost. I mean, if we've got something like 200 foreclosures within the city now.
Yes.
And if it increases to the point to where a lot of these other properties in the area are affected and the values go down, I'm just worried that we might not be able to recover the cost of the attorney's fees plus the rest of this. And I just wanted to make sure that it looks like not the bondholders, the bond payers are protected.
Worst case scenario is the bondholders are the ones that would lose before. The city would not lose any money, and its credit would not be affected because it's a limited obligation, and the property owners would not be affected. They can only be charged a certain amount.
Okay, thank you.
Any other questions? All right, I'll open it up for public comment.